Hi, welcome to the video. If you've been following along with the Tyre Nichols case, then you know that 5 former Memphis police officers have been charged with second-degree murder, among a few other charges. In this video, I'm going to go over one of the follow-up documents to something that has come up involving one of those 5 officers, Demetrius Haley. He is a former corrections officer with Shelby County, and it turns out that there had been a prior civil rights complaint that had been filed against him when he was working in that capacity. I've previously done a video that went over what was in that complaint and probably how that complaint could have been written. I hate to say better because the person who wrote it doesn't have a legal background, but just to sort of give an understanding to some of the things that you can do to make your complaint have more substance to it, some of the things that he sort of left out. Well, in this video, I'm going to now go over the answer that Demetrius Haley's team filed in response to the allegations of civil rights violations. Yeah. Let's go ahead and pop on over to that document so we can take a look at it. It's not that long. It's only 5 pages, but there are a few things that they bring up that I definitely want to touch on. Now, there were 3 people who were actually named in the complaint, and Mr. Sledge had filed the complaint. So it was Shelby County, and the 3 people were David Dyson, Danny McClain, and Demetrius Haley. This is an answer of defendants David Dyson and Demetrius Haley. It says, let's skip on down to answer to complaint. Now, remember, in the complaint, Mr. Sledge had alleged that they said they smelled some contraband and they thought it was him. They took him to the restroom, wanted to do a strip search, and punched him in the face. And one of the officers picked him up and slammed him or something. I don't know. The piece that Demetrius Haley was accused of doing was the face punching. So this answer is in response to this complaint filed by Mr. Sledge that Mr. Haley and this other person had engaged in that activity. All right, answer to complaint. Defendants lack sufficient knowledge to admit or deny the allegations contained in paragraph 1 of the complaint or the subparts of paragraph 1 of the complaint, and those allegations are therefore denied. Now, in the original complaint, let's see if I can pull that up also. Paragraph 1, let's scroll down to that. This is the one that Demetrius Haley is saying they have no knowledge of. This question about previous lawsuits. And what they're going to do is they're going to go through each one of the paragraphs and respond to each one of them. And the second paragraph has to do with present confinement and had he followed the grievance procedures. And if you go back and take a look at my previous video that I did regarding whether or not that procedure has been followed, you know, a lot of times it may not be clear to people, to prisoners, what the process is. Even if you're given the form, even if you're given this manual that has lots of information in it, it can be difficult to follow that and determine exactly what it is that you're supposed to do. So let me click back over now to the actual answer that was filed. So paragraph 2, that was the one where he's saying defendants deny that plaintiff is presently confined in Shelby County Division of Corrections upon information and belief. Defendant has since been released. Defendants lack sufficient knowledge to admit or deny the remaining allegations contained in paragraph 2 of the complaint or the subparts of paragraph 2 of the complaint, and those allegations are therefore denied. So remember, they don't know anything. They're saying we don't know anything about whether or not he filed a grievance, followed the process like he was supposed to. And then the next one has to do with his location. Defendants deny the allegations contained in section A of paragraph 3 of the complaint upon information and belief. Plaintiff Sledge no longer resides at, and the address is given there. It says defendants admit that David Dyson is a correctional officer at Shelby County Division of Corrections. The remaining statements and the subparts of paragraph 3 are not factual allegations to be admitted or denied. Let's check back on what they're talking about there. They're talking about this part here. So they've already talked about this. They've already got the defendants and additional defendants there. So there's not much else to say. I'm not sure what they are denying there. Now we get to 4, where it says defendants admit that plaintiff was taken to a private location to be searched on suspicion of possession of drugs, drug paraphernalia, smoking products, and or smoking paraphernalia. Defendants admit further that defendants assert they observed smoke in the area and that they observed plaintiff attempt to flush contraband down the toilet. The remaining allegations of paragraph 4 are denied. So this thing about the attempt, this has thrown me, it threw me in the complaint. It's throwing me here in the answer. And so they said they observed plaintiff attempt to flush contraband. So was he successful or not? That's the piece I'm not clear on here. So if he wasn't successful, then the next sentence would be he wasn't successful. We confiscated contraband for him and he was disciplined. I keep feeling like this is something that has not been addressed in either one. And I understand that it's not what the complaint is here. They're not complaining about this portion. However, I just feel like it's an unfinished story. Like they haven't told the complete story here. So I keep thinking in my head, okay, so what happened with that? And then they say the remaining allegations of paragraph 4 are denied. Well, what are these remaining allegations that were in paragraph 4? Let's go back to the complaint. This is the part that they are stating is not true. And even though I read this in the complaint when I was going over this, I'm going to go back over it here because we're matching these up. They are responding paragraph by paragraph. And so I want you to be able to say, actually, I want you to be able to see exactly what it is they're responding to. So in this case, this is where Mr. Sledge is supposed to be stating his facts of the case. And if you saw my previous video, then you understand how I felt like Mr. Sledge could have added a whole lot more in here to help tell his story. So he says, officers came into 14 blocks for a random search. They said they seen smoke coming from the area I was in. I was called to the restroom to be strip searched by D. Haley and David Dyson while Sergeant Danny McLean supervised. They said I tried to flush contraband. Okay, so that's the part that I think the answer is saying, okay, we kind of agree with you on that. Here's the part that they are denying. D. Haley and Sergeant Danny McLean hit me in my face with punches, and David Dyson picked me up in the air over his head and slammed me face first into the sink and then to the floor. After that, I blanked out. I woke up at SCDC Medical. That's the part that the answer that they're denying in the answer. Now, what I said in the other video, if you go back and take a look at it, is how I felt like Mr. Sledge could have gone into a whole lot more details. So go back and look at that video if you have not seen that video. But here we're actually focusing a little bit more on the answer. So let's go ahead and take a look at the next section in this answer. Now we're down to number 5, because remember that said, hey, they sort of matched up on paragraph 4, except for the part where he's being hit in the face and slammed. Paragraph 5, defendants deny that the relief sought in paragraph 5 is warranted. They deny that the relief sought in paragraph 6 is warranted. All other allegations contained in the complaint which have not been admitted, denied, or otherwise explained are hereby denied. So they're saying if there's anything we skipped or missed or we didn't explain thoroughly, it's denied too. That's sort of your, I'm going to cover my rear end here. Defendants reserve the right to amend this answer pursuant to the federal rules of civil procedure of this court. And then they go into affirmative other defenses. Now, this is aside from what was in the complaint. Now they're talking about their defenses that they have. First of all, and this first one is one that's typically put in just about any answer. One of the first things you're going to say is that the complaint fails to state a claim upon which relief can be granted against officers Dyson and Haley. Then to all of Officer Dyson and Officer Haley's actions with respect to plaintiff were taken in good faith, were taken within the course and scope of their employment, were based on probable and reasonable cause, including that search is what they're talking about, were those of an objectively reasonable corrections officer, were in accordance with the statutes and common law of the United States of America and the state of Tennessee, and were in accordance with the constitutions of the United States of America and the state of Tennessee. I guess it's in there twice. Officers Dyson and Haley are therefore entitled to qualified immunity under both federal and state law as to the claims alleged by plaintiff. Any damages allegedly suffered by plaintiff resulted from his own acts or omissions and or failure to comply with lawful demands. Okay, so they're saying whatever happened to your face is a result of partially your own actions, and then you failed to comply. So maybe there were some things that we did, but they're not really going into detail here about that. To the extent that plaintiff alleged injuries were caused or contributed by his own unlawful conduct, his recovery for such alleged injuries is barred. Up, and there went my battery saver on. Hold on one second. All right, I think I'm back. Yes. Okay. His recovery for such alleged injuries is barred in whole or in part. Plaintiff's claims are barred to the extent that plaintiff failed to exhaust his administrative remedies. Okay, I'm going to go over this in another video because they're going to talk about how he failed to follow the grievance procedure that by law he has to follow. In order to preserve its affirmative defenses and pending the completion of discovery, defendants allege plaintiff's claims are barred in whole or in part by operation of the doctrine of waiver, unclean hands, laches, equitable estoppel, mistake, and or failure to comply with the requirements of the Prisoner Litigation Reform Act. So this first piece are, hey, you were doing wrong yourself, you weren't following orders, and then you didn't follow this administrative procedure that's required in the Prisoner Litigation Reform Act. It says defendants reserve the right to assert additional affirmative offenses that may be discovered during the course of discovery. For all the reasons contained herein, defendants request that the court dismiss all of plaintiff's claims with prejudice and award defendants all fees, costs, and or all such other relief to which the court deems they are entitled. And then, of course, you have the certificate of service there. So that captures their response, their answer to Mr. Sledge's complaint that he was hit in the face, that he was picked up and slammed into whatever in the restroom, and that this violated his civil rights. They're saying, hey, you weren't complying with what you were supposed to do. You had contraband that you attempted to flush, and you did not follow the Prisoner Litigation Reform Act. And so therefore, we're asking that your claim be dismissed. So there you are. Hopefully this brings you up to speed. Like I said, if you have not checked out the first video that actually goes over the complaint in detail from beginning to end, I know you saw a lot of it here, but there's some additional information in that video. Watch that one, watch this one, and that should bring you up to speed on where things were with the complaint and the answer. Now, we are also going to have a separate video that talks about the motion to dismiss, how this got dismissed, why, and the status of that now. If you got the information you needed, don't forget to like the video and subscribe to the channel. Peace.